Inside a tense federal courtroom, the standard, rigid environment of traditional legal decorum is rapidly losing its grip. A defendant is screaming across the wooden defense tables, attempting to lecture the judge and dominate the proceedings through sheer volume. Then, the judge reaches forward and presses a single button. The audio feed goes dead, and the defendant's ability to disrupt the room vanishes. This confrontation represents a collision between a specific pseudo-legal strategy and the rigid procedural requirements of a federal trial. This is Darrell Brooks. Facing 76 severe criminal charges, he made the decision to fire his entire legal defense team and represent himself. Brooks relied on the sovereign citizen ideology. Adherents of this fringe belief system claim that unless a person explicitly signs a contract with the government, they are exempt from the laws of the land. Brooks used these concepts to inject friction into the trial. He demanded proof of the judge's oath of office, argued over the legal definition of his own name, and built a physical wall out of cardboard evidence boxes on his desk to block the judge's view. By baiting the judge, he hoped to trigger a documented reaction or a threat of contempt. His goal was to create a procedural slip-up that he could later cite as grounds for a mistrial or an appeal. These weren't random outbursts. They were part of a strategy designed to force the judicial process to react to rules it doesn't recognize. For Judge Jennifer Dorow, presiding over this space required absorbing constant psychological pressure. She responded to his aggression with a focused, clinical composure. Engaging in a shouting match would have provided Brooks with the very documentation of bias he needed to challenge a future conviction. While Brooks attempted to derail the proceedings, Judge Dorow sat silently and methodically logged every timestamp and outburst on her notepad. In this setting, the judge treated the defendant's behavior as data to be recorded, rather than a personal provocation. The turning point occurred when Brooks refused to stop shouting over the prosecution's arguments, prompting the judge to change the physical layout of the trial. She ordered the bailiffs to remove Brooks from the main courtroom and place him inside a separate, adjacent room. To preserve his right to be present, the court established a technological bridge. A live audio and video feed connected his isolation room to the judge. This setup gave her new control. She could cut his audio mid-sentence whenever he attempted to block the proceedings. The defendant's primary tool, the ability to stall the trial through noise, was gone. He was left as a silent figure on a screen, visible to the court but unable to interrupt it. This image shows the stacks of federal law books that define the court's rules. With the noise removed, the focus of the trial returned to these organized legal structures. Without the ability to constantly shout and disrupt, Brooks's pseudo-legal theories were forced to stand on their own merits, where they were quickly found to have no basis in actual law. Judge Dorow continued to record his muted objections and systematically overruled them for the record, ensuring no procedural gaps remained. This view of the jury box marks the transition to the final phase of the trial. The facts of the case were finally presented without interruption. When the volume was removed, the sovereign citizen defense was revealed as a series of empty arguments that could not withstand the court's standard procedures. The jury reached a decision quickly. Darrell Brooks was found guilty on all 76 counts. At his sentencing, the defendant's posture shifted from aggressive defiance to visible defeat. The judge sentenced him to multiple consecutive life sentences without the possibility of parole. The trial demonstrates that the most effective response to disruption is the consistent, methodical application of procedure. By refusing to engage in the defendant's tactics, the court ensured the verdict was based on the evidence rather than the chaos.